Thank you for visiting the Coin Lady channel again. My friends, does XRP qualify as a security? Morgan provides official clarification on the court order regarding XRP sales. An unforeseen turn of events has occurred in Ripple's legal battle with the SEC. A prominent attorney and crypto enthusiast named Bill Morgan has joined the fray, leading to a tense Twitter debate. Morgan claims that a major misunderstanding has occurred. Still, could you tell me what it is? In reaction to Stark's claims, you should investigate more to learn more about Morgan's opinions and how they may influence the Bitcoin market as a whole. The discussion took off once Morgan became aware of the accusation leveled by John Reed Stark, a former director of the Securities and Exchange Commission. It is argued that the judge overseeing the Coinbase SEC case had a fundamental difference of opinion with Judge Torres' ruling, which proposed that XRP secondary transactions could be classified as investment contracts or unregistered securities. I had anticipated that disagreement would arise. While I get your perspective and agree with you to a certain degree, I respectfully disagree. The subject of secondary sales was not appropriately brought before the court, according to a statement made by Judge Torres. Morgan wasted little time in denying Stark's claim and saying it was false. He questioned the basis for Failure's dispute, because Torres had not disclosed any information about the secondary market sales of XRP. The argument escalated when a lawyer named Mark Fago questioned Morgan's stance. Token sales through exchanges may not be able to reach the high Howey barrier established by Tories, according to Fago. The critique from Fagles did not bother Morgan, and he politely disagrees with it. He highlighted the SEC's emphasis on discernment and how, according to her determination, these programmatic sales did not meet the essential criteria for investment contracts, and he explained that most tourism analyses focused on Ripple's programmatic sales. Morgan continued by saying that he did not discover any significant proof of widespread dispersion, but that Tories accepted ripples were aimed at institutional investors in their promotion of XRP. As an example of how these specific results cannot be applied to other cryptocurrencies without prejudice, he brought up Solana. Is there more to the Howey tests than meets the eye? Morgan argued against the claim that his decision on programmatic XRP sales automatically rules out the possibility of any cryptocurrency sales on the secondary market being deemed investment contracts. He emphasized that the test was fact-specific and confirmed that Tories' findings do not necessarily rule out every possibility. Morgan concluded that Tories' findings were based on undisputed material, which diminished the SEC's chances of success in its appeal. The expert's opinion is that, after careful consideration, the prospects of successfully appealing the decision, a decision that was taken in July 2023, are exceedingly low, given the emphasis on thorough analysis. It was a watershed moment for the cryptocurrency industry, when XRP was deemed a non-security in transactions involving the secondary market. However, recent developments have raised doubts about this judgment, which has led to inquiries about XRP's regulatory status. Ripple and its investors are understandably anxious, because federal judges are reconsidering the relevance of basic legal principles. I can assure you, it's as significant as it seems. This is a more in-depth analysis, but reassessing the present state of affairs reveals an astonishing twist. 2 federal courts have voiced doubts about the validity of categorizing XRP as a non-security, a crucial part of securities law. Charles Gasparino, a renowned journalist and XRP expert, has cast doubt on Judge Anatoly Torres' interpretation of the Howey test, which is now under scrutiny, and could lead to the classification of XRP as an unregistered security. To refresh the memory of the XRP community, this has resulted in the prospect that the judge's ruling could be reversed. 2 federal judges, one of whom is regarded as the dean of a corporate law court, are involved in this matter. Arguments that use Judge Torres's ruling on Ripple as an example have been ridiculed by Rockoff. Given the irrationality of the finding, it is safe to assume that federal judges are investigating Ripple with an eye toward invalidating the Howey test, a legal threshold crucial to determining whether an asset qualifies as a security. XR. Any reclassification of him would be bad news for Ripple and its constituents. Bill Morgan, an XRP supporter, has remained skeptical despite Gasparini's warning. Morgan challenges the claims made by Gasparini and requests proof of judicial skepticism. These big XRP holders, or whales in the industry, are still buying more XRP despite all the regulatory hurdles, which bodes well for the cryptocurrency's potential future price fluctuations. Nevertheless, XRP's price has been range-bound for over a year, testing investors' patience and requiring market and price analytical prowess. In terms of technical analysis, XRP's price is currently above the crucial 60 cents line, and there are encouraging indications that a possible recovery could be around the corner. Despite the fact that it is subject to overall market conditions, the recovery is expected to reach 7,440 cents, the highest point so far this year, according to analysts. However, there is also a good chance that things could go wrong, which could lead to price losses below important support levels. The market's vulnerability to legal issues is reflected in this. Even while XRP stakeholders are still hoping for a price comeback, the path forward is still filled with hurdles. David Schwartz, Ripple's chief technology officer, addressed a proposal that suggested the company should transfer most of its escrowed tokens to the XRP fund. The RP Ledger Foundation has created an XRP ledger specifically for the XRP community's use. XRP currencies linked to Ripple's and escrow would be more valuable with XRPL, according to Pinos Macris, co-founder of Notice Finance, who proposed the idea. In order to facilitate the team's administration and distribution of tokens among many projects, including marketing awards, educational campaigns, and other initiatives aimed at enhancing the XRP ecosystem, Macri suggested that Ripple contribute XRPL. Is the legal battle that Ripple is having with the SEC more complex than it seems? An unexpected development has also occurred. The argument that Morgan's verdict on programmatic XRP sales automatically rules out all cryptocurrency sales on the secondary market as investment contracts is something he vehemently denied. These big XRP holders, or whales in the industry, are still buying more XRP despite all the regulatory hurdles, which bodes well for the cryptocurrency's potential future price fluctuations. Stakeholders persist in hoping for a price recovery for XRP, but the path ahead is still fraught with challenges. You should not consider the data shown here to be trading advice. Any investments derived from the data shown here are entirely at the investor's risk. Prior to settling on an investment strategy, it is highly recommended that you consult an expert and do your own research. The video ends there. As always, I'd appreciate it if you could subscribe and leave a comment with your opinions. Coming up shortly, farewell.